State of Texas versus Christopher Scott Jones. Could I have parties announced for the record for the state?
Second for the state, Your Honor.
Defense?
Nathan Slemane from Mr. Jones.
Are you Mr. Jones?
Yes, ma'am.
Did you understand you're charged with assault, family second offense, third degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes,
Did
ma'am.
you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison?
That's a big moment. He's facing a third-degree felony with up to 10 years behind bars. The court's offering deferred adjudication, but one wrong move, and that deal disappears. Fast would you take a risk like that?
Prison and up to $10,000 fine.
Yes, ma'am.
Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state recommends deferred adjudication. There's affirmative finding of family violence, no contact with Sidney Jones. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 6 years and that there be no contact with the resident's address. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State offers states 1 and attached.
Without objection.
Court will accept into evidence states exhibits 1 and attachments. State, have you spoken with the complainant?
We have, Your Honor.
Are they aware of this agreement?
They are, Your Honor.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Do you wish to proceed with sentencing?
We'd like to proceed today, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, other than the state and I worked diligently to put this deal together, and we respectfully would request that you honor it.
All right. Are there any alcohol or drug problems with you, sir?
No, ma'am.
All right. Do you just have anger issues?
Yes, ma'am.
All right. And
there it is, 6 years of deferred adjudication. But notice the judge asking about alcohol, anger, even where he'll be living. She's laying the groundwork, one violation, and it's game over.
if you're released today, where will you be living?
With my father.
Does he
Father.
want you to live there?
He's present in the courtroom, Judge.
All right. He wants him to live there?
Yes, Your Honor.
All right. Court will sentence you to 6 years deferred adjudication. How old is the complainant in this case?
18.
All right. Do you have any underage children?
Yes.
What are their ages?
17, 16, 12, 10, 9.
All right. And do you see them on a regular basis?
I'd like to.
Okay. All right. 6 years deferred adjudication, 200 hours of community service restitution, alma mater parenting classes. Once he completes parenting classes, those hours will be deemed satisfied.
Thank you, Judge.
There's to be regular reporting by Zoom or in person. Regular random UAs. You understand while you're on probation, you're not allowed to drink alcohol at all, even in your own home.
Yes, ma'am.
There's an affirmative finding of family violence. There's to be no contact with Sidney Jones or Maruby, M-A-R-U-B-Y, Scarlett Jones. And there's to be no contact with the residents on Clover Street. There's to be the BIPP course, field visits, 1 time per month for 3 months. Then at probation's discretion. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors, and anger management. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? Going to show you? Yes.
The only thing that I'd proffer, Mr. Jones does have a number of minor children. If he has no contact with Maruby, his wife, who's not a victim.
This part's crucial. The court restricts all contact not only with the victim, but also the wife, because she was the victim in a prior assault. This isn't just about legal protection, it's a pattern.
In this case, then co-parenting and making those decisions would be very difficult. We agree with completely no contact with the residents and with the victim. We would ask if, with regards to the wife, who's the mother, just for purposes of co-parenting, we have no harmful contacts with him, at least.
With regards to that, that's going to have to be done through a third party. And the reason why I'm doing that, Mr. Jones, is because, I'm sorry, Mr. Jones, is because your prior assault case is actually against her. So that's why. So I'm not just doing it just to be mean, all right? All right, thank you.
Thank you, Your Honor.
Thank you. All right, so we will to Texas versus Christopher Scott Jones. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
David McLean for the defense.
And are you Christopher Scott Jones?
Sure.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
State?
Your Honor, on or about the 21st day of March 2024, in Ventura County, Texas.
He pleads true to violating the no contact order. That's a direct hit to his probation deal. You can feel the court losing patience. Here, what do you think? Was it love or control?
The defendant, Christopher Scott Jones, did then and there contact Scarlett Jones in person in violation of condition number 19.
How do you plead to that? True or not true?
True.
And then, Your Honor, the state will waive and abandon the others.
Did you understand by pleading true to violation of condition number 19, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 19? Court will find violation of condition number 19 true. The court will let both parties know. The court has received these documents in the court's file. I have not read them because I don't read anything until both parties have had a chance to view them and have any objections to them.
Absolutely, Your Honor.
So have you all both had a chance to review the documents that are sent to the court's file?
I have not heard.
Those are the from last year.
Okay, those are the ones we talked about last time.
That's exactly right. Yeah, there's nothing new. Those are from, nothing from the past like week or two, correct, Your Honor? Those
No.
are, no, so yes, I believe counsel and I have reviewed them in depth, all of them together.
All right. And would you like the court to read these, counsel, or do you have objections?
Essentially, Judge, they're hearsay, but I know the court can consider that.
Well, I mean, if you all have objections to it, then I won't read them. They are hearsay.
I'd object, Judge.
All right. All right. So if the witnesses are not here for the court to read those, then the objection will be sustained.
Thank you.
All right. So is there a proposed agreement?
There is, Judge.
And what is the proposed agreement?
The proposed agreement, Your Honor, is for amending conditions for zero tolerance, house arrest for 30 days, GPS for the remainder of his term, extension for 1 year, and enroll in VIP within 15 days of release.
All right. And who is Scarlett Jones, and why is he contacting Scarlett Jones?
I can get a relationship chart for you, Your Honor. It's a little bit complicated. I can get you an answer, Judge. It's in the file. We literally had to draw this out across a couple of cases, Your Honor. Off the top of my head, I don't know, but I can get that information for you in the state's file.
All right. Is it Scarlett Jones or Sydney Jones?
It's, I believe, Sydney Scarlett Jones.
Okay.
Same person, Judge.
All right. Same person. So I ordered.
No, Scarlett Jones is my wife, Ruby.
Okay. Scarlett Jones is Mr. Jones' wife.
All right. And who is Sydney Jones?
My daughter.
All right. And Scarlett Jones. Okay. The court ordered no contact with Scarlett Jones and Sydney Jones.
And Your Honor, may I ask a quick question? The counsel may know.
Yes.
Ruby, who is that?
No, Scarlett Jones is the person he pled true to the number 19 violation.
Yes.
And I ordered no contact with that person.
Understood.
So I want to know why my no contact orders are being violated. That's where we are. Does anyone want to address that?
Your Honor, this is unfortunately not an uncommon situation that happens when you've got parties that are getting divorced. We have new paramours involved.
So was this contact made at a courthouse?
It wasn't made at a courthouse. It was not, Judge. From what my understanding was, is that he had gone by, and he is struggling.
This is where Judge Boyd draws the line. Her tone shifts from judicial to persona. She's clearly fed up. Why can't people understand when someone doesn't want them anymore? That line hits hard.
Mentally to try to let go of what this relationship was. He misses his kids. He misses his wife. Unfortunately, she's moved on. What I can tell the court is that it appears that there was an application for a protective order filed, correct? My client has agreed to the entry of that protective order. It is a 5-year protective order.
But how old is he?
Who?
How old is your client?
How old is my client?
Yeah.
I would say probably like 40, 45.
All right, so I don't understand what he doesn't understand, that the court ordered a no contact order with Scarlett Jones. I mean, I know you all have your proposed agreement, but I don't know why I should follow this. I ordered no contact with Scarlett Jones. All of this nonsense about people not being able to let go. You can cry, when nobody's around, ask the gods, why am I not with this person? But I told him he couldn't be with her anymore.
Judge, I understand that, and I totally respect your position. Sometimes emotions get better at people, and I'm not saying that's an excuse, but I think that's the reality of what happened. Nobody was harmed. Nobody was, I don't believe in it. Nothing happened from the contact. I'm trying to get this guy back on track.
Yeah, but this is what I want you to understand where I'm coming from. I ordered no contact with Scarlett Jones. I ordered no contact with Sydney Jones. This is an assault family second offense. Probably wouldn't be here, and maybe you would still be in a relationship with them if we were not here for an assault family second offense. So I don't know why people tend to cause problems in relationships and then are shocked when somebody moves on and they don't want you anymore. So I don't know why I should follow your agreement when the main thing the court ordered was no contact. And this is a family violence case. And people don't want people showing up to their door because they've moved on and they don't want you anymore. I don't understand why people don't understand when people don't want to be with you anymore. It's like, I'm over, I'm done. I don't want you anymore. Why can't people internalize that?
I think he has. I think this time in jail has helped him do that. And Judge, if I had a reason for you to follow this, it would be to provide him the assistance that he needs to try and reform himself. I think the battery intervention program alone will do wonders for him. It will open his eyes as to what's going on here. And I also think that, like we said, he's been in jail for about 60 days now. He's going to have another 30 on house arrest. He's going to be on GPS. We can not only monitor him and protect the family, but he's got a protective order in place. I've already explained that to him, and this is for the record. I've explained to him that protective orders have teeth, and that if he violates that, it's not just an MTR next time. He's going to be back in here on a violation of a protective order.
Oh, but my rulings have teeth, and my ruling was
absolutely
there's to be no contact. What has he done on probation other than, get all caught up in his feelings going to somebody's house who doesn't want him anymore? Did he do anger management? Did you do anger
I
management?
enrolled in the PIP. I did 5 classes of PIP so far.
The information I have is I ordered that he was not to have contact with Scarlett Jones. He's saying this is the love of his life. This is somebody he's willing to go to prison for, obviously, because he can't let her go. So I ordered no contact. This is an assault family second. He probably would still be in a relationship with her agreeing to be in a relationship with him if this wasn't an assault family second.
Judge, I understand completely where the court's coming from. I think that my client has had some time to, for lack of a better word, get it together. And I think that he can be successful in this. It's his first MTR. I'd ask the court, please, just allow him to complete these conditions. It's zero tolerance. Explain it to him. And if he comes back.
All right, the court is finding violation of condition number 19 true. The Court is going to find him guilty. There's an affirmative finding of family violence. The court is not going to grant him probation. Would anybody wish to speak to punishment?
Your Honor, I understand the court's ruling. I think that given the facts and circumstances here, and the fact that there's a protective order in place, and my client agreed to that protective order, he has moved on. I think that there is not any imminent danger to Ms. Jones or his family, and I don't see him going by there at all. We would ask, I know the court's got the full range of punishment. The court's not considering probation. We would ask for a minimum on this, a minimum of 2 years. This is not something where on this violation, anybody else was hurt. There's no other violence. And we just ask the court to consider this a minimum on this case.
State.
And then, Your Honor, state, about 10 seconds, Your Honor. State is accessing the legacy system just to get a better handle on the Bear County criminal history, Your Honor. The state would respectfully request something in the range of about 4 years, Your Honor, and that is the state's recommendation.
All right. Court is going to find you guilty. There's an affirmative finding.
4 years in prison, not the full 10, but far from the 2 his defense hoped for. The judge balanced compassion with accountability. Think she was fair? Let us know in the comments.
Finding a family violence. Credit for any time served. There's to be no contact with Sydney Jones or Scarlett Jones. Court will sentence you to 4 years in the prison. All right, we can go off the record. I want you to know, I listened to the arguments of your counsel. I took that into consideration. And sometimes when the prison sentence that I give people think, oh, she's just doing that because the state requested it. There are different things that I'm thinking of in my mind to see what's an appropriate sentence for you. Do I think you deserve the full 10 years for contacting her when what your counsel has told me there was no violence perpetrated? No. So I wasn't going to send you to 10 years, but I don't think 2 years was appropriate for you either. You understand? All right. Good luck to you.